Good morning, everyone. Thank you for joining us. My name is Mahlet Makonnen from Williams Jensen, and I'll be moderating this morning's panel on modernizing the OTC market. During this session, we will be discussing the implication for industry and participants and investors as a result of the recent SEC final rule that amends Exchange Act Rule 15c211. I will, of course, first begin with a brief introduction of our panelists, and then we'll dive right into our questions. We have two great panelists with us today, Dan Zinn and Matt Levine. Dan Zinn is General Counsel of OTC Markets Group. He leads the company's regulatory and policy-making efforts and is often a speaker on over-the-counter equity markets. Prior to joining OTC Markets Group in 2010, he served as outside counsel to OTC Markets as a partner at the Nelson Law Firm, LLC. Previously, Dan worked in the corporate office of AIG. He earned his Juris Doctor degree at the Benjamin and Cardozo School of Law and received his Bachelor of Science from the Pennsylvania State University. Thank you, Dan, for being with us today. We also have with us Matt Levine, who is Deputy General Counsel and Chief Compliance Officer at Virtu Financial. He has been with Virtu and its predecessor firm since 2009. Matt began his career at the Manhattan District Attorney's Office in 1991 and has since counseled clients in private practice, as well as held legal and compliance positions at the New York Stock Exchange, Citigroup, and Merrill Lynch. Thank you, Matt, for being with us today. Thank you both for joining us, and thank you everyone for tuning in. And I'll just start right in with a high-level view of Rule 15c to 11, and that is on September 16th, the SEC adopted amendments to Exchange Act Rule 15c to 11. This rule hasn't been amended in a couple of decades, and in finalizing the rule, the SEC revised some pieces of its original proposed amendments for the rule in response to industry feedback. So I would like you both first to discuss, what is the purpose behind this rule? What was the SEC thinking? And then can you touch on, what industry has clarity on based on the changes present in the final rule that have been amended since the proposal? And I will start with you, Dan, and then Matt, you can chime in as well.
All right. Well, thank you, Mahlet, and thanks to the STA for having me. 15c211 just rolls right off the tongue, right? So easy to get out. I mean, to distill the real purpose of the rule, you probably have to go directly to the commission. But even Brett Redfern in his comments not that long ago today talked about the retail investor protection aspect of what they're trying to do. I think it's important as a baseline to understand the scope of the rule and what it really governs. 15c211 sets forth requirements for a broker-dealer or an interdealer quotation system, which is our kind of trading system, to publish quotes in securities. So the scope of the rule is really not as broad as I think some people may believe. So within that context, the SEC looks at what kind of information is available for retail investors or for the public generally when they go to trade something and when they're looking at broker-dealer quotes in a certain security. So the rule has always had that context to it. And the original version of the rule, as you noted, Mahlet, it's been quite a few decades since they've redone it, really focused on what those initial requirements are and what happens when a company first gets quoted. And then there were some broad-based exemptions that allowed companies to be quoted for a long time. And so what the SEC was looking at here are areas in which they believe retail investors may be more susceptible to fraud. So if you think about companies that haven't provided current information in a really long time, where there's not that kind of balance sheet and income statement and the general financial information that you're used to available, that really seems to be their first focus here. And what they wanted to do was make sure that those kinds of companies aren't quoted in front of retail investors on a regular basis. So those are companies that our system already categorizes as no information, and we put a big stop sign next to their stock symbol on our website. But that's really the main focus. I think some secondary focuses to the rule were to help define the role that a trading system like ours plays in this. And I think the commission looked at all of the work we've done for years in qualifying companies for our OTCQX market or OTCQB market, and all the work we do with company disclosure, and is now allowing industry participants to rely on our determinations or somebody, a system set up similarly to us that provides a similar service. And so I think those dual tracks, certainly focus on investor protection, but also streamlining the way the rule works, were really what kicked off this process and where the SEC wound up with the final rule.
Yeah, and just to add on to that, from my perspective, it seems as if, the SEC, you can have fraud in companies that are making information available, fraud in companies that are not making information available. And it seems to me that, sort of what the SEC attempted to do with this rule was sort of create a bright line test for companies that were not making information available, with the idea that, at least for companies that are making information available, folks can make determinations about, whether it's wise to invest in those companies or not on their own. Whereas, with companies that weren't making information available, the only thing that was that retail investors could see was the quotes that are in the market, last sale information, and to the extent that people were talking about it, the company in chat rooms and things like that, that there could be all kinds of misinformation. And so, again, from my perspective, the SEC sought to create kind of a bright line test to say, all right, if a broker dealer is going to initiate quotations, there's got to be public information available. And then, again, they also, one of the rule changes that I think is a positive rule change is, these are sort of the way that I think of it. They almost have made the OTC markets fit more of a listed market model, in the sense that in the listed markets, issuers will seek to list on an exchange, and the exchanges, have certain, for their various tiers, financial requirements and so forth. And, people will then initiate quotations on the exchange. Here, giving IDQSs like OTC Markets Group the ability to, kind of become almost the listing market, so to speak. Well, it's not quite the same as the exchange. They at least can now do the information gathering, and people can rely on their determination that there's current information available in order to initiate quotations. So I think in that regard, this has been a very positive step.
So we talked about some of the positives of the rule, but obviously it's not a perfect rule. You discussed how the SEC is trying to create this bright line test for companies that are not making some information publicly available. Clearly, after feedback, the SEC, from its proposal, tried to amend its final rule based on that feedback from industry, and parts of the rule still remain uncertain. So I would like you both to kind of go over what parts of the rule still need further guidance from the SEC, given your analysis of the final rule.
In 297 pages, there are still some questions to be answered, for better or worse. And to the credit of the SEC and the staff that's been working on this, they've been really good about providing information, I think, in their releases, and I know in outside communication with interested parties and industry members. To me, that we only have 20 minutes left, but to me, there are a couple of key areas where we still need to define what's going to happen. One of them is the involvement of FINRA. So the way this rule has always worked, there's an SEC component to it, Rule 15C211, and then there is a separate FINRA component that requires a broker to file what's called a Form 211 before starting to quote something. And that's really the rule is set up, the FINRA rule is set up as kind of an information review, a notice filing, just to make sure that FINRA is aware. And over time, that has become more of an approval process, where FINRA is really looking at all of the background information and kind of bordering on merit review in many cases. So while the SEC does not require that form, and even in the proposing release and adopting release, indicated that they don't think it's necessary for, let's say, a system like ours to file those things, it's not at all clear what FINRA's involvement is going to be, and whether that form is still going to be a requirement, whether a broker or somebody like Virtu is going to be able to file that and just reference information that's been made available on our platform, the information review that we've done, So that's going to be a big question going forward. And then I know I'm front running some of the topics we'll get to later, but I think questions around some of the places where the SEC left open the possibility of exemptions or exceptions to the rule, that's going to be key in making sure that the industry is prepared for this. There's a decent timeline set out there where there'll be 11 months from whenever this rule gets published in the Federal Register before it becomes fully effective and the compliance date rolls around. But those are some key things that need to be figured out within that time frame so that everyone has time to build.
Yeah, that's a great point on sort of where's FINRA, in all of this. In the past, it's been the obligation of the broker-dealer to file the 15C211s with FINRA. What I can tell you is for firms like Virtu, where we don't do a lot of original Form 211 filings, and that we're not gathering all of the information. We're typically piggybacking, and so it had been a short form. The securities piggyback eligible. You file your form with FINRA and you put your quotes up. I had one experience where we actually did a Form 211 for an issuer that was an exchange listed issuer, but had some warrants that were trading over the counter, and they didn't want to pay for them to be listed. And to Dan's point, it was, pretty, I think it took us 2 or 3 weeks to actually get the form filed in to the satisfaction of FINRA and, actually get, be able to start quoting. And so, that's a, a pretty significant undertaking. And, to the extent that, OTC markets or firms like that. I know that FINRA is not going to, Virtu is not going to be doing original reviews to make sure, that these things are there and in the rule. Positive thing is if an IDQS says that they've filed, satisfied they filed the form and, the information is publicly available, we can rely on the IDQS's determination. And so, it's our intent to, still try and utilize that sort of a, kind of a short form type of process to be able to initiate our quotations. But I can imagine that, for firms that like IDQSs that are going to want to be doing, the actual information gathering, it really is important that FINRA sort of start dialogue in terms of what they're going to want for these issuers, because it can be a pretty significant amount of work and it can take, a pretty significant amount of time in order to file these forms. So we really do need FINRA to, sort of come to the table and start thinking about, how this is going to, process is going to change. And again, to Dan's point, I think there's, sort of some, scratching around the edges we still need to do in terms of, all the issuers that don't quite, fit into the, we're comfortable that there's public information available, and, assuming that the FINRA process is, a breeze, we can all start initiating quotations. There's still a fair amount of issuers that at this moment in time won't apparently fall into that, we can initiate quotations on for them, but there are a lot of issuers out there that, probably should have a simpler path to being able to have their, at least some information available, whether it's quotations in the normal quotation stream, or there's been some discussion about an expert market and, have some quotations available to, some form of sophisticated investor in that type of a marketplace.
Yeah. And, as Dan mentioned, the rule is a behemoth. It's a lot to go through for anyone, even for experts. And, part of what you both discussed is exceptions. There's a lot of language in the rule about exceptions and changes to exceptions that were present in the original rule. And there was a lot of pushback, as I mentioned earlier, during the original rulemaking process, which part of that is the SEC aimed to eliminate the piggyback exception for shell companies. And the final rule tried to strike a balance by, providing a limited exception. It's just a timeline that I'm sure you'll both discuss. And what are the specifics of that exception, and whether this change from the proposal, which aimed to completely eliminate it, but now there's some timeline where industry participants have some time to have an exception to that. Is this helpful? What is your take on that?
It's better, right? I mean, we're not going to get into the weeds of shell company piggyback eligibility, which is great. So yes, the original proposal, to your point, talked about really removing shell companies for the most part from that category of piggyback eligible and seeing them be subject to continued quotes outside of certain circumstances. And some of that pushback you mentioned, I think Matt and I and our organizations were responsible for a decent chunk of that commentary, along with a number of investors, which I think we'll get into in a minute too. But part of what we and others were talking about was the value that shell companies can have to the capital formation process. And again, looking at the scope of what this rule is, if you're concerned about investors having the appropriate information, sometimes that information is going to say, well, there's not a lot happening in this company right now. It's a shell. It has limited assets or it has limited operations. But as long as that information is made available, there really shouldn't be an artificial clamping down on continued quoting in those companies. And so the SEC responded in the final rule, to your point. They did make a change, and they added an 18-month time frame. So once a shell company, or we can talk in a second about what a shell company actually is, and that may be another one of those areas where more clarity is needed. But a shell company goes through an initial information review, gets quoted, and then can sustain that quote for 18 months. And if you read the release, the SEC is really drawing on some of the rules around blank check companies, thinking about organizations or corporate entities that may not have a lot of operations, but that exist for capital formation because in the case of a shell company, they may be subject to a reverse merger, where a company is going to use that shell company to become public or have its shares publicly traded. And that is one valuable way to use that kind of medium in a similar way to how people think of blank check companies. So 18 months seems like a little bit of a finger in the air. Let's see if that makes sense. I know they're tying it to blank check companies. I think there are arguments to be made that should be a longer time frame. The shell company process doesn't work exactly the same. So there's progress. There's a recognition of the disclosure. There is an understanding that these things need to have a place to be quoted for some period of time. There's another little question about when that 18-month clock starts for companies that are shells at the time the rule goes into effect. So there are, as with probably every topic we'll discuss, there are things we know and things we don't know. But I do think the SEC at least took steps to help make this work for the industry.
Yeah, and from the perspective of market making firms, again, we are very much reactive to our clients, supply and demand needs, and to the extent that there are folks that invest in shell companies because who knows, one day there might be a reverse merger, and that shell may have value, and so it's a cheap way to almost hope you hit the jackpot one day. Again, from our perspective, having good clarity in terms of what can be quoted and what can't be quoted is important because we are reactive to supply and demand, and what will happen at some point for both some of these shell companies and a whole host of other companies that don't have quotes is they're going to no longer be eligible for quotations. That doesn't mean they can't trade, and to the extent that people want to trade them but there are not quotations available, it's going to become really difficult for market makers to be able to handle any significant amount of order flow in companies that don't have information available. There are best execution requirements. FINRA used to have a 3-quote rule. They've sort of gotten away from their 3-quote rule, but I think as sort of a pragmatically, that's how firms still try and satisfy their best execution obligations. And it's going to become really difficult when you have all these different categories of issuers and what can be quoted and what can't be quoted. And again, I think that most market making desks had large rooms full of traders, a number of years ago, and now, things have gone more and more electronic, and to have to be able, to be in a position to be, if someone does want to invest in one of these issuers, to be, manually calling on the telephone or chatting someone in a, over IM to try and find out where a market is just not really feasible for these names. So being able to sort of get to a place where, if there is demand for some of these companies, how do we all satisfy our obligations in a way that is, we're certainly not going to, bring back the days of, football-sized trading rooms with, hundreds of traders. And so being able to sort of manage this type of order flow, whether it's in a shell company or otherwise, is going to, be really difficult. And, being able to have some vehicle that makes that situation better is important for us as market makers, to be able to sort of move forward, as we, have exceptions to the new rules, and we get more sort of clarity in terms of, when will you be able to quote shell companies or any other issuer that isn't making public information available, or if they don't have, they may be making public information available, but that may be we have no nominal operations right now, and is that going to be enough for people?
Yeah, absolutely. And, while we're on the topic of clarity from the SEC, let's talk about future SEC actions, right? Dan, you talked about, both you and Matt actually have commented significantly on different parts of the rule, including, creating a new expert market exception, which would essentially allow the trading of certain securities that no longer qualify for public quoting under the rule. It would take them out as the exception. So while the SEC did not adopt this in its final rule, it did indicate that it was open to considering such a marketplace in the future, of course, following proper groundwork. What do you both believe the SEC is looking for to allow for such an exception, and how would that, operate in relation to the current final rule?
Sure. I think a lot of that goes back to even the initial question that you asked about what's the purpose here and what's the scope of the rule. So thinking about the SEC's retail investor protection goal, there are, and Matt referenced this, there are categories of sophisticated investors that don't qualify as retail. There are differences between how a broker dealer or a registered person or an accredited investor might look at the market and might view continuous public quoting of a security versus a more typical kind of Main Street retail investor. And so the SEC was clear from the outset, I think it was in the first few pages, even of the proposing release, that what they were focused on was market maker quotes being accessible by those kinds of retail investors. And so I think in response to a number of the comments, both industry participants like Matt and I think a number of investors that were part of the comment file, the SEC recognized that having some sort of a market where companies that, those no information, those stop sign companies, can be traded by professionals, can have an electronic quote where brokers can find price discovery and best execution in a manner, much more efficient than what Matt was describing as, IMing or calling people or trying to make a personal connection. You want to make sure that those kinds of investors have access to trading in a market that still fills their needs, and that folks in Virtu's position and others have at their fingertips the ability to fulfill those clients' orders and to work with their traders and their fellow market makers in a way that drives the market in an appropriate fashion. And so that's what the SEC, I think, is signaling in the adopting release when it talks about an expert market. They laid out some pretty specific categories of investors that they believe would be reasonable, that they would categorize as sophisticated for this purpose. And in our comments and others, we've talked about having that kind of electronic market available without the distribution of quotes to retail investors. And that gives effect to the SEC's stated concern and what I think the purpose of this rule is, while also maintaining a real market for those sophisticated investors and those professionals to continue to trade in an efficient manner. So that's I'm encouraged that they put it in the final rule. They don't have to make noise about exceptions if they don't feel like they want to adopt them in the future. So that's very encouraging, and we're obviously working with the staff as much as possible to see those things come to fruition, and hopeful that it works more or less along the lines of what I'm describing and what Matt and I both wrote about in our comment letters.
Yeah, really important, and just to sort of add on to that, there'll be some category of sophisticated investors and, dealers that could see, potentially quotations so that there's some transparency into, what these things might be worth and be able to, give us some basis for providing best execution. An important thing to, consider is that even, the creation of this type of marketplace, your mom and pop won't be able to see those quotes, but it won't prevent mom and pop from hearing about a company that, their friend told them about, and, it's the next hot thing and they want to invest. It doesn't prevent them from sending an order into their retail broker, and assuming their retail broker will take that order and send it to a firm like ours. We need that expert market so that we can service that client that, they may not be able to see the quotes, but they still want to buy the stock. And, the other thing to consider is they may not be able to see quotations, but they will be able to see last sale information. And so they'll, if there's, any kind of active trading, they'll see, there's last sales happening, and they may want to get into the stock. And we need an efficient vehicle for, folks who want to be able to trade, and if there's not an efficient vehicle, ultimately, we are an intermediary, right? We are providing service. We react to supply and demand. And if we're not able to, sort of do this efficiently, people like us just won't provide that service. And so, to the extent that, there is demand in the, market for, these types of securities, we want to at least, there to be, an efficient vehicle for the transaction to happen, for pricing, for people to at least make some, decisions on pricing, and for people to be able to, satisfy their best execution requirements.
Yeah, I mean, to Matt's point, even to take a step back from all of this, there's really only a couple of options. You're either quoted on a public market where quotes are disseminated. You're on the gray market, which is what we call all those securities that have no public quote, no electronic quote at all, where it's that experience Matt was talking about, or you have some solution that is a middle ground that helps service the kinds of investors Matt's talking about, where professionals can access that kind of information. And that's really what the expert market is supposed to provide.
Certainly, and we will keep an eye out for any action from the SEC on this, as they do recognize that there is some room for this marketplace. And to wrap up our discussion, I do have one last question about a topic that everyone loves, which is compliance. The final rule is effective 60 days after publication in the Federal Register. It has not yet been published yet. And the compliance date is 9 months after that. So what happens when the rule is effective? I know you both touched a little bit on that earlier, and when industry participants are required to be in compliance, and just discuss the time frame for that and how the industry should be preparing for this rule.
I know I've jumped in first on all of these, but Matt is a chief compliance officer. I think Matt should take this one.
Yeah. So, for us, we're really trying to, work with, folks to, get some more clarity around the edges. We're also going to need to be able to the record keeping requirements, and so we're still going to have to be able to, if we're relying on an IDQS determination that there's publicly available information, we're going to need to figure out, well, how do we keep those books and records? What are going, and the other things are going to be, what are the timeframes for when an issuer is no longer making information public? And so, what processes do we need to have in place so that we can, pick that information up and then be able to stop quoting in the required timeframes? And, if I sort of have understand the rule correctly, like at some point, when an issuer stops making information public, I think in certain circumstances, you're going to have roughly 2 weeks to stop quoting. And so it's all of the, sort of infrastructure that you need to be able to do. I mean, we are a market maker that quotes, pretty much everything. And, we need electronic mechanisms to sort of take data feeds in and have automated processes do this for us, because you just can't do it on a manual basis. So for us, we're looking at, what is the infrastructure that we need to put in place, as the, timelines for the compliance dates start coming into place, and how are we going to do that? We know, we purchase some data feeds from OTC markets, and to the extent that some of that information can be supplemented in those data streams, that could be one potential way we can satisfy our record keeping requirements, and also trigger stop quoting when we need to quote and things like that. But those are among the things that we're really looking for, so that we can understand what issuers are no longer eligible for quoting and what's the time frame for it. For issuers, once the initial compliance date happens, some issuers are going to become eligible, and other issuers are going to become ineligible. And how do we sort of create the infrastructure to make sure that we're doing all of that in an electronic format and keeping good books and records, so that when we get examined, we can pull out all of our books and records and say, here's how we do it, and here are the electronic records of why we made those determinations.
Yeah, I think from our perspective, a lot of our role is to help make sure that people in Matt's role can do all the things he's talking about. Right? We exist to facilitate trading between our subscribers, and so to the extent they have record keeping requirements, or they are relying on us, as the rule is going to allow them to do, for a lot of this information review, we need to make sure that our systems are matched up, and all of this has to happen. I think the SEC was responsive in giving as much time as they did prior to the compliance date, because there's a lot of technical work that needs to go on. That referenced data feeds. We need to do things like codifying our procedures around what we do to qualify companies. We've been doing this for a long time. And I mentioned earlier, I think the SEC is really giving credence to the work that we do. But now this is going to be a regulatory responsibility that falls on us, and that our subscribers are going to be relying on. So we need to put all of these systems into place, make sure that everybody is connected into them appropriately, so that when we flip the switch on whatever that compliance date is, probably sometime in September of 21, everybody's ready to go. And hopefully we have things like an expert market and maybe some other exceptions that we need to build into that. And everybody can do this in a seamless manner. That's how we view our responsibility. And I think there are a lot of folks in Matt's position who are going to be kind of relying on that. And so we're going to work with them.
Yep.
Great. Well, with that, Matt, Dan, thank you both so very much. This has been very informative, and I'm sure a lot of participants that are looking at this discussion are preparing to comply and have found this very informative. So thank you both, and all of you guys that have tuned in. Thank you for joining us during the session. Enjoy the rest of the conference and have a great day.
Thanks, everyone.
Thanks, Molly. Thanks, Matt.